Before we begin, a quick and important disclaimer. The content provided in this video is for educational and entertainment purposes only. It is intended to offer a historical and sociological analysis of the legal profession and matrimonial law in the United States. This information does not constitute legal advice, nor does it establish an attorney-client relationship. The history of law is complex and varies significantly across different jurisdictions and time periods. Viewers are strongly encouraged to conduct their own due diligence and consult with a qualified, licensed legal professional regarding any specific personal or legal matters. Imagine it is the year 1860. You are trapped in a marriage that is not just unhappy, but fundamentally broken. In the eyes of the law, you do not simply walk away. To even attempt a legal separation, you are essentially declaring war on the social fabric of the United States. In many states, you would have to prove a fault so egregious that it shocked the conscience of the community. You would need a champion, a navigator of the arcane, and a person willing to step into the social crossfire of a scandal-obsessed society. This is the birth of the American divorce lawyer, a figure who has been called everything from a liberator to a homewrecker. Today, the divorce industry in America is a $50 billion a year powerhouse, but its origins are rooted in a time when the very concept of a professional specializing in ending marriages was considered a moral impossibility. This video is the first part of a deep dive masterclass into how this profession transformed from a niche, often shunned legal practice into one of the most influential and lucrative sectors of the American judicial system. The problem we are solving today is one of fundamental understanding. Most Americans view the legal process of divorce as a modern headache, a whirlwind of paperwork, high hourly fees, and emotional exhaustion. However, without understanding the historical trends and the evolution of the legal advocate, it is impossible to navigate or even comprehend why our current system is designed to be so adversarial. By the end of this 10-part series, you will understand the hidden machinery of the American family court. You will see how the shift from divorce by legislature to divorce by judge created a new class of professional power players. We are going to peel back the curtain on the divorce colonies of the 19th century, the era of the private eye lawyer, and the seismic shift of the no-fault revolution. This is not just a history of law. It is a history of American freedom, property, and the changing definition of the pursuit of happiness. To understand the divorce lawyer, we must first understand the vacuum that existed before they were allowed to practice. In the early American colonies, particularly in the South, divorce was almost non-existent. Under English common law, which heavily influenced the colonies, marriage was considered indissoluble. If you wanted a divorce in colonial Virginia, you didn't go to a lawyer. You theoretically had to petition the British Parliament or the king himself. This meant that for the average person, a divorce lawyer was a physical impossibility because there was no court for them to argue in. However, in the Puritan colonies of New England, we see the first seeds of the American divorce attorney. The Puritans viewed marriage not as a sacrament of the church, but as a civil contract. Because it was a contract, it could be broken if the terms were violated. This is where the advocate first appeared. Early petitions in Massachusetts show individuals hiring attorneys, in fact, to argue before the governor and the council. These weren't the polished professionals we see today. They were often general practitioners or even well-read neighbors who understood the specific statutory language required to prove desertion or adultery. The complexity of these early cases cannot be overstated. A lawyer in the 18th century had to navigate the doctrine of coverture, a legal principle where a woman's legal identity was subsumed by her husband upon marriage. This meant a woman couldn't technically hire a lawyer or sue her husband in her own name without a next friend or a male guardian. The early divorce lawyer's first job was often a procedural magic trick, finding a way to give a woman standing in a court that didn't recognize her as a separate legal entity. This involved a step-by-step navigation of equity courts versus common law courts. A lawyer had to decide whether to seek a divorce a mensa et thura, which was a legal separation from bed and board but didn't allow remarriage, or a divorce of vinculo matrimoniae, which was a full dissolution. The stakes were astronomical. Losing a case didn't just mean staying married. It often meant the total loss of property, custody of children, and social standing. As the United States expanded in the early 19th century, the role of the divorce lawyer began to professionalize. We began to see the emergence of case studies in legal journals that provided a blueprint for how to win these cases. This was the era of the legislative divorce. In many states like Pennsylvania and New York, the courts didn't have the power to grant a full divorce. Instead, a lawyer would have to draft a private bill, and lobby the state legislature to pass a specific law just to divorce one couple. Can you imagine the skill set required for this? A divorce lawyer in 1820 had to be part legal scholar and part political lobbyist. They had to present evidence of fault to a committee of politicians. This led to the first instances of professionalized testimony, where lawyers would gather witnesses and depositions to prove a spouse's wrongdoing. It was expensive, it was public, and it was reserved for the elite. This created a massive disparity in the potential outcomes for the wealthy versus the poor, a historical trend that would eventually lead to the massive legal reforms of the late 1800s. The evolution of the profession took a sharp turn when states began transferring the power of divorce from the legislatures to the judicial courts. This is the moment the divorce bar was truly born. Lawyers realized that if they could master the specific statutes of a liberal state, they could attract clients from across the country. This led to the rise of the first divorce mills. In the mid-1800s, states like Indiana and later South Dakota realized that by having shorter residency requirements and broader grounds for divorce, they could boost their local economies. Lawyers in these states became the first specialists. They didn't just practice law, they marketed it. They would send pamphlets to the East Coast advertising their services and the speed of their courts. This was the beginning of the lawyer as a service provider for domestic transition. In this deep dive, we will examine the specific tools these early attorneys used. They had to become experts in the law of evidence. Since divorce required proving a fault, lawyers had to find creative, and sometimes ethically gray, ways to produce evidence of adultery or extreme cruelty. This gave rise to a symbiotic relationship between divorce lawyers and private investigators. By the late 19th century, a high-end divorce lawyer wasn't just a man in a suit in a courtroom. He was the head of an intelligence-gathering operation. We will look at step-by-step breakdowns of how these cases were built, from the initial libel or complaint to the final decree. We will see how the lawyer's role shifted from a moral gatekeeper to a strategic architect. The promise of this masterclass is that you will never look at a standard divorce the same way again. When you see a modern attorney arguing over the division of a 401k or a house, you are seeing the result of 200 years of legal warfare regarding dower rights and community property. We are going to explore the data behind the rise of the profession, looking at how the number of lawyers specializing in domestic relations exploded in tandem with the Industrial Revolution. We will analyze the historical trends that moved us from a society where divorce was a sin to one where it is a right, and the pivotal role the legal profession played in pushing those boundaries. This is part one of our journey into the soul of the American legal system. We are moving from the dark, restricted courtrooms of the 1700s into the high-stakes, high-velocity world of the modern divorce industry. Stay tuned because the history of how we break apart is just as fascinating as the history of how we come together. To understand the mid to late 19th century, we have to look at the divorce lawyer not as a simple mediator, but as a strategist of shame. As we move into the 1870s and 1880s, the legal landscape of the United States was undergoing a radical, albeit quiet, transformation. This era was defined by the fault-based system, a rigid legal structure where one party had to be a villain and the other a victim. For an attorney in 1875, the job was less about property division and more about narrative construction. They were essentially playwrights in a courtroom theater where the script was written in the blood and ink of failed domesticity. Imagine if you are Theodore, a successful merchant in Philadelphia in 1885. Your marriage has disintegrated into a cold, silent arrangement. You want to move on, but in the eyes of Pennsylvania law, unhappiness is not a legal standing. You seek out a lawyer, perhaps a man working out of a dusty office in the shadow of Independence Hall. This lawyer tells you that to achieve your desired potential outcome, you must prove your wife has committed a grievous wrong. In this period, adultery was the primary gold standard for a decree. If adultery was not present, the lawyer had to pivot to the more ambiguous territory of extreme cruelty. This is where the historical trends show the incredible ingenuity of the American legal mind. Lawyers began expanding the definition of cruelty. In the early 1800s, cruelty usually meant physical violence that threatened life or limb. However, by the 1880s, attorneys were arguing for the inclusion of mental cruelty. They began filing petitions claiming that a husband's cold indifference or a wife's public nagging constituted an indignity to the person that made life burdensome. This shift was a massive expansion of the divorce lawyer's toolkit. They weren't just arguing facts. They were arguing psychology before psychology was a formal science in the American courtroom. The step-by-step process of a 19th-century divorce case was a grueling marathon of public exposure. First, the attorney would file a libel, which was the formal complaint. This document was often published in local newspapers to serve as notice. Imagine the social impact of having your most intimate domestic failures printed next to the price of wheat and ads for patent medicine. This public shaming was a deliberate part of the legal mechanism, intended to discourage frivolous suits. The lawyer's role was to manage this fallout. They had to be a public relations agent, ensuring that the evidence presented in the libel was strong enough to survive the scrutiny of a judgmental public. One of the most fascinating case studies from this period involves the rise of the professional witness. Because the law required proof of fault, and because many couples actually agreed that they wanted to part ways, a phenomenon known as collusive divorce emerged. Here the lawyer became a shadow director. To satisfy the judge, the lawyer might suggest that the husband be seen in a compromising position. They would hire individuals to provide the necessary testimony. This led to the birth of a specialized investigative industry that served the divorce bar. Lawyers would coordinate with these early private eyes to manufacture the evidence needed to bypass the strict moral codes of the era. This was a high-stakes game. If a judge suspected collusion, the case would be dismissed instantly, and the lawyer could face disbarment. The attorney had to walk a razor-thin line between effective advocacy and legal fraud. The data from this era is staggering. A landmark 1887 federal report, the first of its kind commissioned by the Department of Labor, revealed that between 1867 and 1886, over 328,000 divorces were granted in the United States. While this might seem small compared to 2026 figures at the time, it represented a 157% increase, far outstripping the population growth. This data proved that the divorce lawyer was no longer a fringe actor. They were a central figure in the shifting American social contract. The report showed that the vast majority of these divorces were granted on the grounds of desertion and cruelty, proving that lawyers were successfully moving away from the narrow confines of adultery. We must also look at the financial architecture of these early cases. This was the era of the first real alimony battles. Before the Married Women's Property Acts were passed in various states throughout the mid to late 19th century, a woman's assets often became her husband's upon marriage. When the marriage ended, the lawyer had to navigate the complex transition from coverture to independent ownership. The attorney became an accountant, tracing the origin of dowries, inherited land, and family businesses. They were laying the groundwork for the modern equitable distribution laws we see today. They had to argue that a wife's contribution to the household, or the assets she brought into the union, entitled her to a portion of the husband's estate. These weren't just legal arguments. They were revolutionary claims about the value of domestic labor and the economic rights of women. Step by step, the lawyer's strategy involved several key phases. After the libel was filed and the notice was served, the discovery phase began. In 1890, this didn't involve digital forensic audits. It involved taking depositions from servants, neighbors, and disgruntled relatives. The lawyer had to be an expert in the law of hearsay and a master of cross-examination. They had to filter through the gossip of a small town to find the admissible evidence that would hold up in a court of record. The final phase was the trial itself, often held before a judge who viewed the dissolution of marriage as a personal affront to the stability of the republic. The lawyer's closing argument had to be a masterpiece of moral justification, framing the divorce not as a rejection of marriage, but as a necessary pruning of a dead branch to save the tree of society. As we reached the turn of the century, the profession saw the emergence of the divorce colony specialist. Places like Sioux Falls, South Dakota, became magnets for those seeking a faster potential outcome. South Dakota had a residency requirement of only 90 days and recognized a wide array of grounds for divorce. Lawyers in Chicago and New York would form partnerships with South Dakota attorneys. They would package the entire experience: the travel, the 3-month stay in a local hotel, and the guaranteed legal representation. This was the first time in American history that divorce law became a streamlined, commercialized service. It was the precursor to the Reno divorce era of the 20th century. Attorneys in these colonies were making more in 3 months than most general practitioners made in a year. They were the pioneers of legal marketing, using the disparity between state laws to create a lucrative national market. However, a new conflict was brewing. As the 19th century closed, the backlash against these easy divorces reached a fever pitch. Religious groups and conservative legislators began demanding a national uniform divorce law to stop the migration of scandal. The divorce lawyer, once seen as a necessary evil for the elite, was now being blamed for the destruction of the American family. Attorneys had to adapt once again, shifting their public image from fixers to protectors of the innocent. They began to emphasize their role in securing child custody and protecting women from abusive environments. This transition was vital for the profession's survival. Imagine the tension as the calendar turned to 1900. The divorce lawyer was now a permanent, if controversial, fixture of the American legal system. But the biggest shifts were yet to come. The era of the private eye lawyer was about to get much more technological and much more dangerous. In the next part of this masterclass, we are going to dive into the 1920s and 30s, an era of celebrity scandals and the rise of the Reno Cure. We will see how the lawyer's role evolved from a local advocate to a high society power broker. We will explore the secret world of the staged adultery photos and the legal loopholes that allowed the rich and famous to swap spouses like high-end real estate. What happened when the law itself became a farce that everyone, including the judges, was in on? The era of the great American divorce mill is about to begin, and the lawyers were the ones holding the keys to the factory. Welcome to the 1920s, an era of roaring prosperity, jazz, and a fundamental breakdown in the traditional American domestic structure. By this point, the divorce lawyer had moved from the shadows into the spotlight of high society. If you were a person of means in 1925, your divorce lawyer was as essential as your stockbroker or your tailor. But there was a massive, glaring problem that defined the profession during this decade. The law was stuck in the 19th century, while the culture had already sprinted into the 20th. This disconnect created a golden age of legal theater, a period where the attorney was less of a litigator and more of a director of elaborate, staged performances designed to satisfy archaic statutes. To understand the historical trends of this era, we have to look at the New York legal bottleneck. In the 1920s and 30s, New York was the financial and cultural capital of the world, yet its divorce laws were among the most restrictive in the United States. Adultery was the only ground for an absolute divorce. This meant that even if a couple mutually agreed that their marriage was over, they had to prove a sexual betrayal in a court of law. For the New York divorce lawyer, this led to the professionalization of the staged adultery scandal. Imagine if you are James, a wealthy executive in Manhattan in 1928. You and your wife have lived in separate wings of your mansion for 3 years. You want to move on, but neither of you has actually committed adultery. Your lawyer, sitting behind a massive mahogany desk, explains the standard operating procedure for achieving a successful potential outcome. This is not about truth. It is about the appearance of truth. The lawyer coordinates a specific step-by-step sequence of events. First, you are instructed to check into a high-end hotel, such as the Waldorf Astoria. Second, the lawyer hires a professional correspondent, usually a young woman who makes a living by appearing in these legal charades. Third, at a prearranged time, usually around 2 a.m., a private investigator and a photographer, both paid for through your lawyer's office, burst into the room. The photographer snaps a picture of you in your silk robe, sitting on the edge of the bed with the correspondent, who is also strategically dressed. No actual sexual contact occurs. The woman then leaves through a side door. The lawyer now has the physical evidence required by the New York statutes. In court, the private investigator testifies as an unbiased witness to the discovery of the infidelity. This was the era of the wink and nod justice system. Everyone in the room, the judge, the bailiff, the opposing counsel, knew the scene was staged. However, because the procedural requirements were met, the divorce was granted. This created a lucrative sub-industry for lawyers who could manage these scandals without letting them spiral into genuine public disgrace. While New York was mired in staged scandals, the state of Nevada was pioneering a completely different historical trend: the migratory divorce. This is where the divorce lawyer became a travel agent and a hospitality mogul. In 1931, during the depths of the Great Depression, the Nevada legislature saw a unique economic opportunity. While other states were struggling with bank failures, Nevada decided to capitalize on the misery of failed marriages. They lowered the residency requirement for a divorce to a mere 6 weeks. This gave birth to the Reno Cure. Case studies from the 1930s show a massive influx of wealthy Americans heading west. The role of the lawyer here was logistical. A New York or Chicago attorney would refer their client to a Nevada associate. The step-by-step process was refined to a science. The client would arrive in Reno and check into a divorce ranch. These weren't standard hotels. They were high-end retreats designed specifically for the 6-week waiting period. The Nevada lawyer would visit the ranch, coaching the client on how to establish legal residency. They had to be seen in town, they had to open a local bank account, and they had to be prepared to testify that they intended to make Nevada their permanent home, even though everyone knew they were leaving the moment the decree was signed. The data behind this movement is incredible. In 1931 alone, Reno granted over 4,000 divorces, a staggering number for a town of its size. By the mid-1930s, this number jumped to over 30,000 annually. The fees generated for the local legal bar were the lifeblood of the Nevada economy. This period represents the first time that divorce law became an interstate commerce issue. It created a legal tension that wouldn't be resolved for decades. If a Reno lawyer secures a divorce for a New York resident, is that divorce valid when the person returns to New York? This led to the landmark Supreme Court cases of Williams versus North Carolina, which lawyers had to study obsessively to ensure their clients weren't accidentally committing bigamy when they remarried. During this time, we also see the rise of the celebrity divorce lawyer. With the explosion of the motion picture industry in Hollywood, the stakes for domestic litigation reached new heights. For a star like Mary Pickford or Charlie Chaplin, a divorce wasn't just a private matter. It was a threat to a multi-million-dollar brand. The Hollywood divorce lawyer became a master of the non-disclosure agreement and the private settlement. They realized that the public courtroom was a liability. This era saw the transition toward private negotiations held in smoke-filled rooms, where lawyers would trade assets for silence. They were navigating a world where the morals clause in a studio contract could end a career. The lawyer's job was to protect the asset, the celebrity themselves, from the legal consequences of their personal lives. Step by step, the lawyer's strategy in high society cases shifted toward financial forensic work. Although we didn't have the digital tools we have in 2026, the 1930s lawyer was adept at tracing hidden bank accounts, offshore holdings, and shell companies used to hide wealth from a soon-to-be ex-spouse. They were the architects of the first prenuptial agreements, though they were rarely called that at the time. They were drafting complex trust structures to ensure that even if a marriage failed, the family fortune remained intact. However, as the 1930s drew to a close, a new crisis emerged. The proliferation of these easy, migratory divorces began to undermine the authority of the law itself. When the legal process becomes a transparent farce, the public loses respect for the judiciary. Lawyers found themselves in a defensive position, fighting against a wave of new regulations aimed at curbing the divorce mills. This set the stage for a massive ideological battle. On one side were the traditionalists who wanted to return to the strict, fault-based systems of the past. On the other side were the progressive lawyers who argued that the law should reflect the reality of human relationships. Imagine the courtroom in 1939. The lawyer stands before a judge, arguing a case that everyone knows is based on a lie. Yet the law demands the lie be told. The tension was becoming unsustainable. The legal profession was reaching a breaking point where the theater of fault would have to give way to something more honest, or the entire system would collapse under the weight of its own hypocrisy. As we move into the next phase of this deep dive masterclass, we are going to look at the post-World War II era. This was a time of massive social upheaval, where millions of returning GIs faced the reality of marriages that couldn't survive the strain of war. We will explore the rise of the domestic relations court and the first attempts to bring social science and psychology into the legal process. What happens when the lawyer is asked not just to end a marriage but to fix a family? And how did the invention of the television change the way Americans viewed the divorce lawyer forever? The era of the high-stakes custody battle is about to begin, and the legal strategies were about to get much more personal. In the next part, we examine the birth of the modern family court and the lawyer's new role as the guardian of the child's best interests. What happens when the focus shifts from who is at fault to who is the better parent? The answer changed the American legal landscape forever. The year 1946 marked a tectonic shift in the American domestic landscape. As millions of soldiers returned from the battlefields of Europe and the Pacific, the United States faced an unprecedented surge in marital dissolution. Historical trends show that in 1946 alone, the divorce rate spiked to 18.2 per 1,000 married women, a record that would remain untouched until the social upheavals of the 1970s. For the divorce lawyer, this wasn't just a period of high demand. It was a period where the fundamental questions of the law began to change. For over a century, the attorney's primary objective was to assign blame. But in the post-war era, a new, more complicated question emerged. What happens to the children? Imagine if you are Robert in 1952. You are a suburban father in Ohio, a veteran of the Great War, and and a middle manager at a growing manufacturing firm. Your marriage to Linda, which began in a whirlwind of patriotic fervor before you deployed, has reached a point of irreconcilable silence. You both want a divorce, but there is a 3-year-old daughter, Susan, caught in the middle. In 1952, your lawyer would explain that the potential outcomes of a custody battle were largely dictated by a legal principle known as the tender years doctrine. This doctrine was a massive historical shift from the 1800s, where children were often viewed as the legal property of the father. By the 1950s, the pendulum had swung entirely in the other direction, creating a judicial presumption that mothers were the naturally superior caregivers for young children. For a lawyer representing a father like Robert, the step-by-step strategy was no longer just about proving the wife committed adultery. Instead, the lawyer had to become a character assassin of a different sort. They had to prove the mother was unfit. This is where we see the birth of the modern high-conflict custody battle. To win custody for a father in the mid-20th century, a lawyer had to document evidence of what was then considered moral or psychological failure. Was the mother a heavy drinker? Did she frequent jazz clubs? Did she fail to keep a clean house? The attorney would hire private investigators to photograph unwashed dishes, or to follow the mother to social gatherings. This was an era where the lawyer's desk was often covered in photographs and affidavits from neighbors testifying to a parent's domestic habits. Step by step, the litigation of custody in the 1950s followed a rigid high-stakes path. First, the lawyer would file for a temporary custody order, often an ex parte motion, meaning the other side wasn't even present. This was a strategic strike to establish the child's residence early on. Second, the lawyer would initiate a series of depositions, not just of the spouses but of teachers, pediatricians, and local clergy. This was the first time in history that the legal profession began to lean heavily on social science. Lawyers started bringing in the first wave of child psychologists to testify about the emotional welfare of the child. However, these experts weren't the neutral evaluators we see in 2026. They were partisan witnesses hired to bolster the lawyer's specific narrative of who was the better parent. The role of the divorce lawyer also expanded into the realm of financial support, specifically the emergence of child support as a standardized legal obligation. Before this era, alimony was the primary focus intended to support the wife. But as the 1950s progressed, the lawyer's role became focused on the economic survival of the child. Attorneys had to navigate a landscape where there were no standardized child support tables or state-mandated calculators. Every dollar was a battle. The lawyer had to argue based on the father's standard of living versus the child's actual needs. This created a massive disparity in potential outcomes, where a skilled lawyer could secure a settlement that either guaranteed a child's future or left a mother and child in near poverty. Case studies from the 1950s and early 60s highlight the emergence of the family court as a distinct entity. Previously, divorce was handled in general civil courts alongside contract disputes and personal injury cases. But as the volume of cases grew, states began creating specialized courts designed to handle the unique emotional and social complexities of family law. This professionalization of the bench forced the divorce lawyer to adapt. They couldn't just be aggressive litigators. They had to understand the specific temperament of the family court judges, who were often more interested in social stability than strict legal technicalities. One of the most significant historical trends during this time was the move toward the best interests of the child standard. While the tender years doctrine was still dominant, the legal language began to shift. Lawyers started arguing that the court's primary duty wasn't to punish the at-fault spouse, but to protect the child's future. This opened a new door for legal strategy. An attorney could now argue for joint custody arrangements, though these were extremely rare and often viewed with suspicion by the courts. The lawyer became a negotiator of time, carving out weekends and holidays in a way that had never been formalized in previous centuries. By the mid-1960s, the pressure on the fault-based system was reaching a boiling point. Lawyers were tired of the staged adultery and the manufactured evidence required to get their clients out of miserable marriages. The profession was essentially operating in a state of institutionalized perjury. Judges knew the evidence was fake, lawyers knew the evidence was fake, and the clients were paying thousands of dollars to participate in the charade. This friction led to the most significant legal revolution in American history: the invention of no-fault divorce. Data from the American Bar Association shows that by 1965, the legal community was overwhelmingly in favor of reform. They realized that the adversarial nature of the fault system was doing irreparable harm to the very children the courts were trying to protect. Lawyers were the ones drafting the new statutes that would eventually allow a couple to divorce simply because they no longer got along. This was a radical departure from the idea of marriage as a permanent, unbreakable covenant overseen by the state. The divorce lawyer was about to transition from a hunter of faults to a distributor of assets. Imagine the professional anxiety of a divorce lawyer in 1969. For decades, your entire career was built on proving someone was a bad person. Now the law was moving toward a system where blame was legally irrelevant. How would you justify your fees? How would you win for your client if you couldn't use their spouse's indiscretions against them? The answer lay in the complexity of the modern American estate. As the middle class grew, so did the assets. Pensions, suburban homes, stocks, and business interests. The divorce lawyer was about to become a forensic accountant. But before we get to the no-fault revolution, we have to talk about the final days of the old guard. In the next part of this masterclass, we are going into the 1960s, an era of radical social change and the final desperate gasp of the fault-based system. We will look at how the civil rights movement and the rise of second-wave feminism forced the divorce lawyer to rethink everything they knew about gender, property, and power. What happened when women started entering the legal profession in large numbers and taking on these cases themselves? And how did one single law passed in California by a future president of the United States change the lives of every American family forever? The no-fault revolution is coming, and it is going to blow the doors off the traditional courtroom. Get ready, because the way we break up is about to get a whole lot faster and a whole lot more expensive. The year was 1969, and in the governor's mansion in California, Ronald Reagan was about to sign a piece of legislation that would fundamentally rewrite the social contract of the American family. This was the Family Law Act of 1969, and it introduced the concept of no-fault divorce to the United States. For over a century, the divorce lawyer had been a merchant of blame, a specialist in finding the cracks in a person's moral character to leverage a legal exit. Suddenly, the landscape shifted. Under this new law, which became effective in 1970, a spouse no longer had to prove adultery, abandonment, or cruelty. They simply had to state that the marriage had suffered from irreconcilable differences. Historical trends show that this was not just a minor tweak in the law. It was a total demolition of the old guard. For the legal profession, this meant that the potential outcomes of a case were no longer tied to who was the villain. In 2026, we look back at this as the moment the divorce lawyer had to stop being a detective and start being a forensic accountant. This transition was chaotic, controversial, and extremely lucrative for those who could master the new rules of the game. The 1970s became the decade of the Great American Divorce Boom, where the number of annual divorces in the United States doubled between 1970 and 1980. Imagine if you are Sarah, a woman in Los Angeles in 1974. Your husband, David, is a successful aerospace engineer. Under the old fault-based system, if you wanted to leave David but had no proof of a specific legal wrong, you were essentially trapped. You would have had to hire a lawyer to manufacture a scandal, risking your reputation and your financial future. But now, in the era of no fault, your lawyer tells you that the court doesn't care why you are leaving. The focus has shifted entirely to the division of the marital estate. Your lawyer's primary job is no longer to catch David in a hotel room. It is to find out exactly how much David's pension from Lockheed is worth, and how much of it belongs to you. This leads us to a critical case study of the 1970s, the struggle over professional degrees and future earning capacity. Lawyers in this era were pioneering a new form of legal warfare. In cases like Sullivan versus Sullivan, attorneys argued that if a wife worked to put her husband through medical or law school, the degree itself was a marital asset. They argued that the marriage was an economic partnership, and the lawyer's role was to calculate the return on investment. This required a step-by-step financial analysis that the legal profession had never seen before. Step 1. The lawyer would hire an actuary to project the husband's lifetime earnings with the degree versus without it. Step 2. They would calculate the wife's financial contribution and her lost opportunity cost. Step 3. They would present this to a judge as a tangible asset to be divided. This was the birth of the modern valuation expert in the divorce courtroom. The lawyer was now coordinating a team of financial professionals, turning the divorce process into a high-stakes corporate merger in reverse. However, the historical trends of the 1970s also reveal a darker side to the no-fault revolution. While it made exiting a marriage easier, it often led to what sociologists call the feminization of poverty. Because lawyers no longer had the leverage of fault, they couldn't use a husband's bad behavior to secure higher alimony payments. Many women found themselves divorced quickly, but left with inadequate financial support. The divorce lawyer had to adapt again, shifting their strategy from moral outrage to equitable distribution. In states that followed community property laws like California, the rule was a strict 50-50 split. But in equitable distribution states, the lawyer had to argue what was fair, a much more subjective and legally complex battle. The data from this period shows a massive increase in the complexity of filings. A standard divorce petition in 1950 might have been 3 pages long. By 1975, with the inclusion of detailed financial disclosures, tax returns, and property appraisals, a filing could easily reach 50 pages. The lawyer's workflow became a marathon of discovery. Step by step, the lawyer had to issue subpoenas for bank records, audit corporate books, and depose business partners. They were looking for hidden assets, a practice that became increasingly common as spouses realized that the law was now going to take half of everything they owned. We must also look at the role of the 1970s lawyer in the rising conflict of joint custody. Before this decade, custody was almost always awarded to the mother. But with the rise of the women's liberation movement and the changing roles of fathers, lawyers began to push for joint legal and physical custody. This was a radical idea that most judges initially resisted. An attorney in 1978 had to be a pioneer, arguing that a father's involvement was vital for a child's development. They used new psychological studies to prove that the best interests of the child were served by maintaining strong bonds with both parents. This created a new area of specialization, the high-conflict custody litigator. By the late 1970s, the image of the divorce lawyer had transformed. They were no longer the shady figures from the era of staged scandals. They were becoming high-powered, highly paid professionals who understood the tax code as well as they understood the family code. They were the architects of the modern American family's financial restructuring. This era also saw the first major wave of women entering the divorce bar. These female attorneys brought a different perspective to the table, often focusing on the long-term economic security of women and children, and they began to challenge the male-dominated judicial system from within. Imagine the atmosphere in a law office in 1979. The shelves were no longer just filled with case law books, they were filled with tax guides and real estate manuals. The lawyer was a strategist in a world where the stakes were no longer just about personal freedom, but about the survival of the middle-class dream. They were navigating the complexities of inflation, the rise of the two-income household, and the emergence of the 401k as the primary vehicle for American wealth. As we conclude this part of our deep dive masterclass, we have seen how the no-fault revolution broke the old system and created a new financialized world of domestic litigation. But the 1980s were about to take this to an entirely different level. We are moving into the era of the megadivorce, the decade of greed where assets weren't just houses and cars, but global empires and celebrity brands. What happens when the divorce lawyer has to divide $1 billion fortune? And how did the 1980s give us the cultural archetype of the shark lawyer, a figure who would do anything to win? In the next part, we dive into the War of the Roses era. We will look at the rise of the superstar divorce attorney in New York and London, the lawyers who represented Donald Trump and Ivana Trump, and the high-stakes world of the prenuptial agreement. What happens when the legal battle becomes a front-page tabloid sensation? The gloves are coming off and the fees are about to go through the roof. The era of the divorce lawyer as a global power broker is next. The 1980s ushered in a period of American history defined by conspicuous consumption, corporate rating, and the celebration of extreme wealth. For the American divorce lawyer, this decade was a transformative era where the profession shed its last vestiges of quiet, behind-closed-doors mediation, and stepped fully into the glare of the tabloid spotlight. This was the decade of the megadivorce, where the assets under scrutiny were no longer just the family home and a station wagon, but international conglomerates, art collections, and intellectual property. Historical trends from this era show that as the divorce rate stabilized at its historic high, the complexity and cost of the litigation exploded, giving rise to the cultural archetype of the shark lawyer. Imagine if you are Mark, a high-flying investment banker in Manhattan in 1987. You have spent the last decade accumulating a portfolio of luxury real estate, a minority stake in a private equity firm, and a collection of modern art that is appreciating by 20% a year. Your marriage to Elena has collapsed under the weight of 80-hour work weeks and the pressures of New York high society. When you walk into your lawyer's office, a glass-walled fortress overlooking Central Park, the conversation is no longer about irreconcilable differences. It is about a tactical, step-by-step deconstruction of your financial life. The divorce lawyer of the 1980s had to become a master of corporate law. They were no longer just practitioners of the family code. They were dealing with the valuation of closely held corporations. A key case study of this era involves the landmark litigation surrounding the valuation of a spouse's interest in a professional partnership. Lawyers had to argue over the value of goodwill, the intangible reputation of a business or a professional practice. If a lawyer represented the spouse of a famous surgeon or a top-tier architect, they had to prove that the brand name of that professional was a marital asset that could be quantified and divided. This required a level of financial sophistication that changed the hiring practices of top law firms. They began recruiting heavily from the worlds of forensic accounting and business valuation. Step by step, the lawyer's process for a high-net-worth individual in the 80s followed a rigorous path of financial discovery. Step 1. The issuance of comprehensive document requests that span 10 years of tax returns, bank statements, and corporate ledgers. Step 2. The hiring of specialized appraisers to value everything from racehorses to Caribbean vacation homes. Step 3. The use of the deposition to trap a spouse into admitting to the existence of offshore accounts or hidden cash flows. This was the era of the paper war, where lawyers would bury the opposing side in thousands of pages of documents, hoping to find a single inconsistency that could leverage a multi-million-dollar settlement. One of the most significant historical trends of the 1980s was the mainstreaming of the prenuptial agreement. Before this decade, prenups were often viewed as the province of the ultra-wealthy or the suspiciously cynical. However, as the divorce rate remained near 50%, the legal profession began marketing the prenup as a necessary tool for financial planning. The lawyer's role was to draft an agreement that could withstand the scrutiny of a judge 10 or 20 years later. This was a legal minefield. A lawyer had to ensure full financial disclosure at the time of signing. Otherwise, the entire document could be thrown out. They had to navigate the unconscionability standard, ensuring the agreement wasn't so one-sided that it shocked the conscience of the court. This led to the practice of independent counsel, where each party had to have their own lawyer to review the prenup, creating two billable events before the marriage even began. The 1980s also gave us the celebrity divorce as a national spectator sport. The case of Donald and Ivana Trump in the late 80s and early 90s serves as a perfect case study for how the divorce lawyer became a media strategist. The legal battle wasn't just fought in the courtroom. It was fought in the pages of the New York Post and the Daily News. Lawyers realized that by leaking information to the press, they could exert immense pressure on the opposing party to settle. If a lawyer could damage a spouse's public image or threaten their business reputation, they could achieve a potential outcome that the law alone might not provide. This birthed the era of the litigation PR specialist, a professional hired by the law firm to manage the narrative of the divorce in the public eye. Data from the American Bar Association during this period indicates a massive rise in the hourly rates of matrimonial attorneys in major metropolitan areas. In 1980, a top divorce lawyer might charge $200 an hour. By 1989, that figure had tripled in cities like New York, Los Angeles, and Chicago. This was driven by the sheer amount of money at stake. When the marital estate is worth $100 million, a legal fee of $1 million is seen as a necessary cost of doing business. The divorce lawyer had transitioned from a domestic counselor into a high-stakes negotiator, who functioned much like a mergers and acquisitions attorney. We also see the rise of the War of the Roses mentality, named after the popular 1989 film. This reflected a historical trend of extreme adversarial litigation where the goal was not just to end the marriage, but to financially and emotionally liquidate the opponent. Lawyers were often criticized for fueling this fire to increase their billable hours. This led to a step-by-step escalation of legal tactics, including the use of temporary restraining orders to lock a spouse out of their own home, or the freezing of corporate assets to halt a spouse's business operations. The lawyer was the commander of this domestic war, using every procedural tool in the book to gain a tactical advantage. However, by the end of the 1980s, the legal system was beginning to buckle under the weight of this extreme litigation. Courts were backlogged for years with divorce cases. The emotional and financial toll on families was becoming a matter of public concern. This set the stage for a counter-movement that would define the next decade. As the 1990s approached, the legal profession began to see the emergence of alternative dispute resolution. The very lawyers who had built their reputations as sharks began to face a new reality where clients were demanding a faster, less destructive way to part ways. As we move into the next part of this deep dive masterclass, we will explore the 1990s and the rise of the Kinder gentler divorce. We will look at the birth of mediation and collaborative law, where lawyers are trained to find common ground rather than scorched earth. We will examine the O.J. Simpson trial's unexpected impact on how Americans viewed legal advocacy and domestic disputes. What happens when the public realizes that the win-at-all-costs mentality of the 80s has left the family court system in shambles? And how did the arrival of the internet in the late 90s change the way lawyers find hidden assets and communicate with their clients? The digital age of divorce is about to begin, and the strategies were about to become much more data-driven. Stay tuned, because the transition from the courtroom shark to the boardroom mediator is the next great chapter in American legal history. The 1990s arrived not with a bang, but with a collective sigh of exhaustion from the American legal system. The scorched earth tactics of the 1980s had left a trail of depleted bank accounts, traumatized children, and a judiciary that was increasingly hostile toward matrimonial attorneys who treated the courtroom like a gladiatorial arena. By 1990, the historical trends were clear. The cost of a contested divorce was rising at a rate that far outstripped inflation, and the potential outcomes for the average family were becoming increasingly bleak. It was in this atmosphere of frustration that a revolutionary idea began to take hold, forever changing the role of the divorce lawyer from a courtroom shark to a boardroom mediator. To understand this shift, we have to look at a pivotal moment in 1990 in Minneapolis, Minnesota. A veteran divorce lawyer named Stuart Webb, after years of high-conflict litigation, reached a breaking point. He decided he would no longer represent clients in court. Instead, he proposed a model where lawyers would be hired solely to negotiate a settlement. If the case went to court, both lawyers would be disqualified from further representation. This was the birth of collaborative law, and it represents one of the most significant architectural shifts in the history of the American legal profession. It moved the lawyer's financial incentive away from prolonging conflict and toward achieving a resolution. Imagine if you are Michael and Jennifer in 1995, living in a suburb of Chicago. You have 2 children, a mortgage, and a modest portfolio of mutual funds. Under the old 1980s model, your respective lawyers might have spent 6 months fighting over who gets the grandfather clock, billing you by the 10th of an hour for every angry phone call. But in the 1990s, your attorney might suggest a different path: mediation. Looking back from our vantage point in 2026, we can see that this was the decade when the neutral third party became the most powerful person in the room. The step-by-step process of a 1990s mediation session was a far cry from the dramatic cross-examinations of the past. First, the parties and their lawyers would meet with a mediator, often a retired judge or a specially trained attorney. Second, the mediator would establish ground rules focused on interest-based negotiation rather than rights-based litigation. Third, instead of asking what the law requires, the mediator would ask what the family needs to move forward. This process allowed for creative potential outcomes that a judge simply didn't have the authority to order, such as complex bird-nesting custody arrangements or unique property offsets that avoided the immediate sale of a family home. Case studies from this era show that mediation wasn't just about being nice, it was about efficiency and data. By the mid-90s, the legal profession was integrating early spreadsheet software, like Excel, to run multiple financial scenarios in real time. Lawyers were no longer scribbling on legal pads. They were projecting the tax implications of alimony payments and the future value of college savings accounts with mathematical precision. This data-driven approach allowed for a more objective discussion of the marital estate, taking much of the emotional heat out of the financial deconstruction. However, the 1990s also brought a new and complicated layer to the discovery process: the birth of the digital footprint. In 1992, if a lawyer wanted to find evidence of hidden spending, they looked at canceled checks and credit card statements. By 1998, the rise of the internet and services like AOL changed everything. This was the era of the first e-discovery battles. Imagine a lawyer in 1999 realizing that their client's spouse had been communicating with a secret partner via email. There were no established rules for how to handle digital evidence. Lawyers had to argue over whether a hard drive could be subpoenaed and how to authenticate a printed-out email. This was a technological frontier that required the divorce lawyer to become a tech-savvy investigator, navigating the early Wild West of digital privacy laws. The historical trends of the 1990s were also heavily influenced by the 1994 Violence Against Women Act, VAWA. This federal legislation had a profound impact on how divorce lawyers handled cases involving domestic abuse. Before the mid-90s, abuse was often treated as a secondary issue in many family courts, sometimes even dismissed as a tactical move in a custody battle. Post-VAWA and following the massive public awareness generated by the O.J. Simpson trial, the legal profession began to treat allegations of domestic violence with a new level of gravity. Lawyers had to develop specialized protocols for protecting clients, utilizing emergency protective orders and supervised visitation centers. The lawyer's role expanded to include a high-stakes safety coordination element, working closely with law enforcement and social workers. Data from the late 90s indicates that as mediation and collaborative law took root, the number of divorce cases actually going to a full trial began to plummet. By 1999, it was estimated that fewer than 5% of divorce cases in some jurisdictions were reaching a final judicial adjudication. This didn't mean that lawyers were making less money. It meant they were being paid for a different set of skills. They were now being valued for their ability to manage complex negotiations and for their expertise in the burgeoning field of psychological child development. The lawyer became a coordinator of experts, bringing in vocational evaluators to determine a spouse's earning capacity and child custody evaluators to provide deep dives into the family dynamic. Step by step, the 1990s lawyer was also navigating the first wave of the internationalization of divorce. As the global economy expanded, it became more common for a couple to have assets in multiple countries, or for one parent to want to move a child across international borders. This led to the increased importance of the Hague Convention on the civil aspects of international child abduction. A divorce lawyer in 1997 had to understand international treaties and foreign legal systems, adding a layer of complexity that would have been unimaginable to a practitioner 50 years prior. As we reached the turn of the millennium, the divorce lawyer was a professional in transition. They were standing between the old world of physical evidence and courtroom drama, and the new world of digital footprints and alternative dispute resolution. The image of the lawyer as a cold-blooded litigator was being replaced by the image of the lawyer as a sophisticated problem solver. But even as the process became more civilized, a new force was gathering on the horizon that would disrupt the privacy of the divorce process more than any law or court order ever could. Imagine the dawn of the year 2000. The internet is no longer a novelty. It is a utility. Cell phones are becoming ubiquitous. A new era of social connectivity is about to explode, and with it, the very definition of privacy in a marriage is about to vanish. In the next part of this masterclass, we are moving into the 2000s and the rise of the social media divorce. We will explore how platforms like MySpace and later Facebook turned the divorce lawyer into a digital forensic specialist. We will look at the rise of the electronic smoking gun, and how a single status update or a tagged photo could derail a multi-million-dollar settlement. What happens when your private life becomes a permanent, public record that your spouse's lawyer can access with the click of a button? The era of the digital paper trail is next, and the stakes have never been more public. Stay tuned because the history of the divorce lawyer is about to get a lot more social and a lot more complicated. As the clock struck midnight on the new millennium, the American divorce lawyer entered a landscape that was physically the same but digitally unrecognizable. The year 2000 brought the realization that the private lives of Americans were no longer contained within the four walls of the family home or the locked drawers of a roll-top desk. We were entering the era of the digital footprint, a time when the historical trends of matrimonial law would be dictated by server logs, hard drives, and the fledgling world of social networking. If the 1980s were about the paper war, the 2000s were about the forensic war. Imagine if you are Christopher, a software developer in San Francisco in the year 2004. You are going through a dissolution of marriage with your spouse, and your primary concern is the division of stock options from your startup. Your lawyer, a specialist in the burgeoning field of electronic discovery, doesn't just ask for your bank statements. Instead, they issue a preservation letter to your spouse's employer and a subpoena for their Yahoo Mail account. This was the moment the divorce lawyer had to become a technologist. The step-by-step process of discovery shifted from reviewing photocopies to analyzing metadata. To understand the depth of this shift, we must look at the specific legal mechanics that emerged. The American Academy of Matrimonial Lawyers reported a massive spike in cases involving digital evidence during this decade. In 2000, digital evidence was a novelty. By 2010, it was the primary driver of successful potential outcomes. The lawyer's workflow began to include a digital forensic audit as a standard first step. Step 1 involved the imaging of hard drives to capture deleted files. Step 2 was the analysis of browser history to track spending patterns or secret travel. Step 3 was the cross-referencing of cell phone tower pings with credit card transactions to build a chronological map of a spouse's movements. This era also saw the birth of the social media divorce. When MySpace launched in 2003 and Facebook went public in 2006, they provided a treasure trove of evidence that was technically public but emotionally private. Case studies from this period highlight the incredible lack of digital literacy among the general public, which lawyers exploited for their clients' benefit. Consider a case from 2008 where a husband claimed in court that he was unemployed and could not afford child support. Historical trends also show that this digital era changed the nature of child custody battles. Imagine if you are a mother in 2009 fighting for primary custody. Your husband's lawyer produces a series of your own tweets from 2 a.m. on a Tuesday, implying you were at a bar while the children were supposedly in your care. This led to the emergence of the social media audit as a defensive strategy. Divorce lawyers began instructing their clients to go dark, to deactivate all social accounts the moment a petition was filed. The lawyer's role became one of reputation management in a world where nothing is ever truly deleted. We must also analyze the impact of the Stored Communications Act, SCA. Lawyers had to navigate the complex federal laws that governed how and when an internet service provider could release private messages. This led to a step-by-step evolution in how subpoenas were drafted. A lawyer couldn't just ask for everything. They had to be specific, citing non-content records like login times and IP logs to circumvent certain privacy protections. They were testing the limits of the Fourth Amendment in the context of a private civil dispute. This was a high-stakes legal laboratory where the rules for the next 50 years were being written in real time. By the time we reached 2012, the legal profession was grappling with the rise of the smartphone. The BlackBerry and then the iPhone meant that every American was carrying a tracking device in their pocket. For the divorce lawyer, this was the ultimate gift. GPS data from a phone could prove a spouse was not where they said they were. Text messages, which people tended to treat with less caution than emails, became the #1 source of incriminating evidence. The lawyer's strategy shifted toward securing the physical device as quickly as possible. This led to emergency orders for the preservation of electronic evidence, a new legal tool used to prevent a spouse from accidentally dropping their phone in the toilet the day after a divorce filing. In 2026, we look back at the 2000s as the decade that killed the secret. The divorce lawyer of this era was the one who taught the American public that their digital life was their real life. They pioneered the use of data as a weapon of moral and financial leverage. But even as the digital world became more transparent, the social world was becoming more diverse. The very definition of who could get a divorce was about to undergo its most significant expansion since the founding of the Republic. As we move into the final chapters of this deep dive masterclass, we are going to look at the 2010s and the 2020s. We will explore the seismic impact of Obergefell versus Hodges and the unique legal challenges of same-sex divorce. We will examine the rise of the gray divorce trend among the baby boomer generation and the emergence of cryptocurrency as the ultimate hidden asset. What happens when a spouse hides $5 million in a digital wallet that requires a 12-word seed phrase to access? And how is artificial intelligence in 2026 changing the way lawyers predict judicial outcomes before they even step into a courtroom? The modern era of divorce is defined by equality, complexity, and the total integration of technology. In the next part, we look at the lawyers who broke the gender barriers of marriage law and the new frontier of the blockchain breakup. The future of the American family is being litigated right now, and the tools are more powerful than ever. Stay tuned because the final evolution of the divorce lawyer is about to be revealed. As we moved into the 2010s, the American divorce lawyer found themselves at the center of the most significant expansion of civil rights in a generation. The year 2015 stands as a monumental pillar in this historical trend, marked by the Supreme Court's decision in Obergefell versus Hodges. This ruling didn't just change the definition of marriage, it fundamentally transformed the landscape of family law for millions of Americans. For the divorce lawyer, this meant navigating a legal wilderness where the rules of the past were suddenly applied to unions that had existed in a state of legal limbo for decades. Imagine if you are David and Robert in 2026, but your story begins in 1990. You were a couple for 35 years, lived in a house you bought together in 1995, and raised a family, yet you could only legally marry in 2015. When you decide to dissolve your marriage in 2026, your lawyer faces a task of unprecedented complexity. The central question becomes, what is the date of the marriage for the purpose of property division? Is it the legal date on the certificate from 2015? Or is it the date you first began commingling assets in the 1990s? This created a massive demand for lawyers who could argue the doctrine of common law marriage and equitable distribution in ways that had never been tested. Lawyers had to perform a step-by-step forensic reconstruction of a 30-year relationship, arguing for the transmutation of separate property into marital property based on decades of shared intent, rather than a simple legal document. The data from this period shows that the potential outcomes for same-sex couples were often dictated by the creativity of their legal counsel. Attorneys had to become experts in retroactive tax filings and the complex world of the Qualified Domestic Relations Order, or QDRO. This legal mechanism is essential for dividing pension and retirement funds. In 2026, a lawyer dealing with a gray divorce or a same-sex dissolution must use a QDRO to ensure that a spouse receives their fair share of a 401k or a defined benefit pension without triggering immediate tax penalties. This is a highly technical process where a single clerical error can lead to the loss of hundreds of thousands of dollars in future benefits. The lawyer's role shifted toward that of a meticulous financial engineer, ensuring that the deconstruction of the estate didn't result in a catastrophic loss of value. While the 2015 ruling was expanding the pool of potential clients, another historical trend was emerging that would change the economics of the profession: the rise of the gray divorce. According to data from Pew Research and the United States Census Bureau, while divorce rates for younger populations began to stabilize or even decline, the rate for Americans over the age of 50 doubled between 1990 and the 2020s. For those over 65, the rate tripled. This created a new specialization for the divorce lawyer: the advocate for the silver splitter. In a gray divorce, the issues are rarely about child custody. Instead, they are about the long-term survival of two people who no longer have their primary earning years ahead of them. The lawyer must navigate the complexities of Social Security benefits, where a spouse may be entitled to half of their former partner's benefit if the marriage lasted at least 10 years. The step-by-step strategy for a gray divorce lawyer in 2026 involves a deep dive into healthcare planning and long-term care insurance. They have to ensure that the division of assets doesn't leave one spouse ineligible for future government assistance or unable to cover the rising costs of medical care. This is a delicate balancing act of math and empathy, where the lawyer is often planning for a client's needs 20 or 30 years into the future. However, just as the social and demographic shifts were taking hold, a technological revolution was preparing to hand the divorce lawyer their most difficult challenge yet: the blockchain. In the mid to late 2010s, and accelerating into the 2020s, cryptocurrency became the ultimate weapon for hiding assets. Imagine a character named Michael who, in 2022, quietly moved $300,000 of marital savings into Bitcoin, Ethereum, and a series of anonymous altcoins. When he files for divorce in 2026, he tells his wife and the court that the money was lost in bad stock market investments. For the modern divorce lawyer, this requires a completely new step-by-step forensic protocol. Step 1 involves the issuance of specialized subpoenas to crypto exchanges like Coinbase or Kraken, but the savvy lawyer knows that many assets are held in cold storage, physical wallets not connected to the internet. Step 2 involves a physical search of the home for seed phrases, which are a series of 12 to 24 words that act as the master key to a digital vault. Step 3 involves hiring a blockchain forensic analyst who can trace transactions on the public ledger. Even if the lawyer can see that the money exists, they face the massive hurdle of not your keys, not your coins. If the spouse refuses to provide the private key, the lawyer must petition the court for extreme sanctions, including contempt of court or a disparate award of other marital assets to offset the hidden crypto. The data shows that as of 2026, nearly 15% of high net worth divorce cases involve some form of digital asset dispute. This has forced the legal profession to integrate artificial intelligence into their discovery process. AI tools in 2026 can now scan through thousands of pages of bank statements in seconds, flagging tiny, recurring payments to crypto on-ramps that a human eye might miss. These tools can also predict potential outcomes based on a specific judge's past rulings on digital asset concealment. The lawyer is no longer just an advocate. They are the operator of a sophisticated data mining operation. The 2020s also brought the era of the pandemic-driven pivot. The global lockdowns of the early 2020s forced the American legal system to go virtual almost overnight. This change, which many thought would be temporary, has become a permanent feature of the landscape in 2026. The divorce lawyer now operates in a world of Zoom courts and digital evidence portals. This has lowered the barrier to entry for many clients, But it has also changed the psychology of the process. The dramatic face-to-face confrontations of the past have been replaced by the sterile environment of a video call. This has made the lawyer's ability to read body language and manage emotional volatility through a screen a critical new skill set. Historical trends indicate that this virtualization has led to an increase in mediation. When people aren't sitting in the same room, the physical tension is lower, allowing lawyers to push for collaborative settlements more effectively. But it has also led to a more transactional view of the process. In 2026, we see a rise in unbundled legal services, where a client might hire a lawyer just to draft the property settlement, but handle the rest of the filing themselves. This is a democratization of the law, but it carries the risk of people missing the long-term financial traps that a full-service attorney would catch. As we stand in 2026, the divorce lawyer is a hybrid professional, part tax expert, part digital forensic investigator, part psychologist, and part technologist. They are navigating a world where the family unit is more diverse, the assets are more invisible, and the process is more virtual than at any point in American history. They have moved from the 18th century champion of moral fault to the 21st century architect of digital and financial equity. But even with all this technology and all these new laws, one thing remains constant. The human heart is still at the center of the storm. In our final part of this deep dive masterclass, we are going to look at the ultimate evolution of the divorce lawyer. We will examine the rise of the artificial intelligence attorney and the ethical debate over whether a machine can ever truly replace the human judgment required in a family crisis. We will look at the globalized future of divorce, where families are spread across continents and jurisdictions. And finally, we will ask the most important question of all. After 300 years of evolution, has the divorce lawyer made the process any better, or just more complicated? The finale is next, and it will challenge everything you think you know about the future of the American family. Stay tuned for the final chapter of this historic deep dive. The question of whether the legal process of divorce has become objectively better, or simply more intricate, is the defining debate of the 2020s. As we stand here in 2026, the American divorce lawyer has completed a 300-year transformation from a moral gatekeeper to a data-driven architect of social and financial transition. We have moved from a world where a woman had no legal standing to a world where a machine can predict the division of a 401k with 95% accuracy. But as technology reaches its zenith, the profession is facing its most existential challenge yet: the rise of artificial intelligence and the automation of the advocate. To understand the 2026 landscape, we must look at the step-by-step integration of predictive judicial analytics. Imagine if you are Alex, a mid-career professional in Seattle. Your lawyer doesn't just guess how a judge might rule on your specific custody arrangement. Instead, they use a proprietary AI model that has ingested every single ruling handed down by Judge Henderson over the last 15 years. The software performs a sentiment analysis on the judge's past language regarding primary versus secondary caregivers. Step 1. The lawyer uploads your historical data, including work schedules and school involvement. Step 2. The AI identifies a historical trend where this specific judge favors stability in the existing school district by a margin of 60%. Step 3. Your lawyer uses this data to craft a settlement proposal that aligns perfectly with the judge's known biases, effectively winning the case before it ever enters a courtroom. This is the reality of the high-end 2026 divorce bar. We are seeing a move away from the high-conflict litigation of the 1980s and toward a system of algorithmic certainty. However, this creates a new divide in the potential outcomes for Americans. While wealthy clients utilize bespoke AI-augmented advocacy, middle-class families are increasingly turning to unbundled, automated legal services. This is the productization of divorce. For a flat fee, an AI bot drafts the petition, handles the service of process via digital notification, and uses a standardized calculator to divide assets. The historical trend here is a return to a form of administrative divorce, similar to the early 19th century legislative acts, but powered by silicon rather than politics. Consider a case study involving a digital nomad couple in 2026. Liam and Sophia were married in Nevada, but spent the last 3 years working remotely across 4 different countries and 3 different U.S. states. They own a virtual real estate portfolio in a decentralized metaverse, and a significant amount of staked Ethereum. Their primary asset is not a physical house, but a high-yield intellectual property license for a piece of software they co-developed. A traditional lawyer from 1990 would be completely lost in this jurisdictional and technological labyrinth. The 2026 divorce lawyer must navigate the step-by-step process of international service under the Hague Convention, while simultaneously conducting a forensic audit of a blockchain. They have to argue for the valuation of virtual assets that have no physical footprint, and whose value can fluctuate by 30% in a single afternoon. The lawyer's strategy involves hiring a digital asset appraiser, who specializes in NFT royalty streams. This is the new frontier of equitable distribution. The potential outcomes are no longer just about who gets the car. They are about who gets the recurring revenue from a smart contract that could pay out for the next 50 years. We must also address the ethical evolution of the profession. As AI begins to handle the math, the human divorce lawyer is being forced to lean back into the role of the psychological counselor, a role they largely abandoned during the financialized era of the 1980s. In 2026, the most successful attorneys are those who market themselves as strategic emotional navigators. They realize that while a machine can divide a bank account, it cannot navigate the grief of a 30-year marriage ending or the complexities of a child's emotional resilience. The lawyer's value proposition has shifted from "I am the person who knows the law" to "I am the person who knows how to get you through this without destroying your family." Data from the American Bar Association in 2026 indicates a surge in the use of collaborative law and mandatory mediation. In many jurisdictions, you are now legally prohibited from stepping into a courtroom until you have completed a minimum of 20 hours of professional mediation. This is the ultimate victory of the 1990s reform movement. The adversarial system is being slowly phased out in favor of a restorative justice model for families. The divorce lawyer's role in this system is as a negotiator-in-chief, focused on future-focused problem-solving rather than past-focused blame. However, the historical trends also point to a growing crisis of digital privacy. In 2026, every person carries a digital twin, a massive repository of every text, every location ping, every heart rate spike recorded by a smartwatch, and every private search query. In high-conflict cases, lawyers are now litigating the admissibility of biometric data. Imagine if a lawyer uses your own fitness tracker data to prove you were in a state of high physiological stress during a supervised visit with your child, arguing that you are emotionally unstable. This is the dark side of the data-driven divorce. The lawyer has become a digital archaeologist, digging through the layers of a person's cyber existence to find the one data point that shifts the leverage. Step by step, we have seen the evolution of the American divorce lawyer through 10 distinct eras. We began in the 1700s with the rare, almost impossible petition to the crown. We moved through the 1800s era of public shame and fault-based theater. We witnessed the mid-20th century rise of the private eye and the 1970s no-fault revolution. We watched the 1980s create the courtroom shark and the 1990s birth the mediator. We navigated the 2000s digital explosion and the 2010s civil rights expansion. And now, in 2026, we see the lawyer as a master of AI and blockchain forensics. The final verdict on the American divorce lawyer is that they are the most accurate mirror of our society's values. When we valued moral purity, they gave us the fault system. When we valued economic growth, they gave us complex asset division. When we valued equality, they gave us the no-fault revolution. And now, as we value data and efficiency, they are giving us the automated divorce. The profession has survived because it is infinitely adaptable. As long as the human heart remains capable of making a commitment, and then finding it impossible to keep, the divorce lawyer will exist as the navigator of that painful transition. As we conclude this deep dive masterclass, you now understand the hidden machinery of the American family court. You see that a divorce is not just a personal ending. It is a legal, financial, and technological reconstruction of a life. The history of the divorce lawyer is the history of the American family's search for a way to fail with dignity and a way to start over with security. In our next series, we will take this historical perspective and apply it to a different sector of the American economy, looking at the evolution of the corporate raider and the rise of the Silicon Valley venture capitalist. The legal and financial structures of our lives are built on these histories. By understanding where we came from, you are better equipped to navigate where you are going. Thank you for completing this deep dive into the evolution of the American divorce lawyer.